Good morning. You may be seated. Is that all lighting that's available here? Place is dark. Advocate Hassan.
Justice, may I request the camera people to change the direction of the lights a little so it's not shining right in our faces?
Yeah. I think when we adjourn, the people from the province should come and tell us what has changed. During the tea break, if they could come through to me, let me understand what is all this and why we are here. And is the other room fitted with screens for the rest of the people who want to watch? Do you know, Council?
I'm not aware. I was not aware that we would be in this room at all today, Justice.
Does anybody know if the other room is fitted with screens for more people?
Yes.
And obviously chairs where people could sit and watch this. You should nonetheless come and see me during tea break, right? And help me understand what's all this. Shall we start? We're going to be with you in a moment. Are there any housekeeping matters that we ought to deal with?
Not from our side, thank you, Justice Moseneke.
Not from our side either, Justice.
There's nothing for now, Justice Moseneke.
Well, Council, no? Nothing. Okay. Council?
We are ready to proceed with the cross-examination.
Yes, indeed. It will come through to you in a moment. But I'd like to know what steps have been taken so far in relation to the application brought in the High Court by Dr. Silibano. I have to make up my mind whether I file a notice of intention to oppose as time moves on, and that is dependent on what the other parties are doing. Do we know now? I mean, those parties specifically cited, and the state in particular.
Justice, as far as I understand, there is counsel who has been appointed to deal with that application. There are time frames within which have been set out for the filing of the answering affidavit, and I understand that they are working on that in order to meet the deadline as set out in the notice of motion. And the appointment of the other counsel was necessitated by the need to continue with this proceedings. So as far as I understand, steps are being taken to do everything that's necessary to file the necessary affidavit in accordance with the time frames set out in the notice of motion.
Do we know whether the state parties would be opposing the application?
Well, that's what I understand, that the object of the filing of the answering affidavit is in opposition of the relief sought in the notice of motion.
I follow. I'm asking this only because I've been cited as a party, and I've got to make up my mind whether I file a notice to oppose or a notice to abide. And that will be influenced by whether or not there is otherwise opposition.
Justice, perhaps I should just make this point that to the extent that there are other interested parties to that application, it might be prudent for those parties to the application, or those parties who have interest in the application, to take necessary steps to ensure that they make their position clear by joining in the proceedings. As we know that the subpoena was issued subsequent to the discussions which the parties had with regard to the need to ensure that people are in attendance. And to the extent that any of the parties feels strongly that that witness has to make appearance before these proceedings, it might be advisable that like such parties should be able to take steps to join in those proceedings and not just leave it to the state. We are all parties to these proceedings, but like that responsibility should not be only left to the state as they are representing other parties to this arbitration.
Sure. That is, I think that is a correct position. Would any of the other parties want to say anything at this stage? No.
Justice Moseneke, we're not prepared to give any undertaking or otherwise at this stage.
Justice, I'm still taking instructions on this. We were not cited as a party. The state was cited as a party because they were the party who caused the subpoena to be issued. We've tended to provide an affidavit to support the case of the state insofar as the understanding of the terms of reference of this arbitration go. All of the parties are clear, and there's consensus amongst the parties about the terms of the arbitration. We've also requested that the state provide us with their papers so that we know whether and how to intervene if necessary.
Yes, no, very well. Counsel, is there anything you want to say at this stage?
Nothing at this stage, Justice Moseneke.
Okay.
We'll comment later.
Well, Justice, I think we share the same sentiments as Section 27, in that at this point in time we don't have proper instructions to oppose the application, but we feel that the state, being a party to the urgent application and being the party who caused the subpoena to be issued, should go and attend to the urgent application and should oppose it on the legal basis that we feel that there's no legal grounds for that urgent application. But be that as it may, we still reserve the right to join those proceedings depending on the actions of the state.
Very well, I think we should proceed. You are under your previous oath to tell the truth and nothing but the truth. And I'm going to invite counsel for the state to continue the cross-examination. Advocate Utamo.
Thank you, Justice. Good morning, Ms. Trotter.
Good morning.
When we adjourned last week, Friday, we were still dealing with your testimony. And I should remind you that our questions are purely based on what you have already testified on during examination in chief by advocate for Section 27. So, in essence, we'll be trying to clarify some of those matters which you have testified on.
I'm sorry, counsel, to interrupt you now. There was a request that you ensure, camera people, that your flashes are not directed into the faces of those, particularly counsel who are working here. So you have to do your best from where you are But just keep that in mind, please. You may continue.
Thank you. Ms. Trotter, you will recall that during your testimony, you made mention of the fact that there was a team which had to interview some of the affected families in relation to the tragedy in relation to the mental health care users. Do you recall that?
I do.
And during questioning, you were asked a question which related to your objective or the objective in relation to your appearance before these proceedings. And if I recall, I just want to try and verify if like I got your evidence correct. When during examination chief, you indicated that you had to come before these proceedings to formulate an argument in terms of why the impact was so devastating. Do you remember that? You were asked a question, what was the objective of your project with the rest of the team? Your response was that it was to try and understand how the individual members of the families had experienced this entire process from the very beginning and to look at the impact that it had on them, and also to formulate an argument in terms of what impact was so devastating. Do you recall that evidence?
Yes.
So and then you continued to say that, so the information essentially came from the families, but then it was pulled together in a particular way to create an argument. Do you recall that?
Yes.
So, like as you say, like your objective is essentially to create an argument on behalf of the affected family members.
My objective is to try and understand how the family members experience this from a psychological and emotional point of view, and then using all my psychological theory to be able to explain that impact on them. I mean, I'm not attached at all to the word argument. It's a way of making sense of what they've gone through using all the theory that is available to us.
So essentially, from what you had initially said, that like you wanted to make an argument for them, that was not appropriate.
No, I wouldn't say that. What I would say is that the way which I learnt on Friday, the way that you use terms legally is not the same as the way lay people use terms, or the way that I would use terms as a psychoanalyst and clinical psychologist. So for me, it's one particular word. I could use the word linking things together. I could talk about making sense of things. It's that I use that word differently to how you might.
Okay. I think like before you, like there should be a bundle, which is the report of your team, the report prepared by your team, the supplemented one, LR 56.
I don't have that. I've got LR 1 to 51, 51 plus.
Try and see if you can locate.
King assists the witness to find the report. It's essentially her report.
Yes.
But it's in here. I'm sorry, I can't find it. Happy to use my report.
It's LR 56.
Okay, thanks, King.
On the front end of it.
Yes, but it wasn't in the file.
Is it not there?
It wasn't in the file, no.
Oh, I see, okay. But do you have it at hand now?
Yeah, I've got it.
LR 56 is nothing more than your supplementary affidavit and the attached to which is the report, Mark CT1. You may continue, Counsel.
You will recall that in relation to this document, you gave testimony that you were asked by counsel for Section 27 essentially to read a specific article. And I just want to refer that article, which appears at page 41 of the report. According to your evidence, you stated that counsel asked you to read the Hillsborough report and add it, which is partly why you got a new report. Essentially, your evidence was that you were requested by counsel to read this report, which appears at page 41, so that like it can be added to this report. And it is exactly the reason why this report had to be supplemented. Do you recall that?
It's part of the reason. The real issue was that there were, as much as we'd read the report, a serious number of typing errors, and I was unhappy with that. So I had already asked if I could give another report that was deposed, so that the report in the public record was free of error, because in a situation like this, that seems to me to be particularly important.
Yes, but like from what you have said is that like during your interaction with counsel for Section 27, she actually engaged you to identify one of the documents which was found to be critical to these proceedings.
Certainly not critical. Council alerted me to two documents. The one was the Health Ombuds report, and then I was alerted to this document. I could entirely have ignored the email. I mean, it was up to me to read it, to decide how to use it, how not to use it, and the same with the Ombuds report.
So, like, I clearly understand you that, like, you say counsel alerted you to at least two documents.
Correct.
The first being the Ombuds report.
Yes.
And then the second being the report appearing at page 41 of ELA.
Correct.
And then you were requested to at least add it into the revised, edited report.
No, that wasn't the request. The request was, see if this is helpful in any way, and then given that we are redeposing the document, let's put it at the end, because I'm sure you can see the similarities in terms of the Hillsborough tragedy and how this situation has unfolded.
Yes, I take it that the document is quite helpful in order to make that comparison. But like what we try to understand from you is that like this came through the assistance of counsel.
As did the Ombuds report.
As also in respect of the Ombuds report. Okay, thank
But
you.
I was free to use it in my own way or not.
And in your testimony, you testify that you had your own methodology of doing the assessment.
That's correct.
And counsel also alerted you to certain documents which you had to include in the production of your report.
Not at all. The only thing I received were 56 affidavits.
Say that again?
The only thing I received, apart from the I was alerted to the Ombuds report and the Hillsborough report. Other than that, the only thing I received from council were the 56 affidavits. No other reports.
Ms. Trotter, I put it to you that as an expert, you were required to do your work independently without being influenced by a party to the proceedings.
That's correct, and that's what we did.
And in this instance, you have stated that counsel for Section 27 alerted you of documents which had to be considered in the preparation of a report.
No, not had to be considered. They were available, I was alerted to them. There was absolutely no pressure on me to consider them at all.
Did you consider the documents?
The Ombuds report I have read backwards and forwards. The Hillsborough report I read. Look, it was interesting to read a report about a similar situation. There were only 3 things in the entire report that I thought, it's a 122-page report, that I thought were in any way relevant or useful. So it was not, for me, the most useful document. And by that time, my argument or the links that I'd made were there, and I've got a 6-page reference list. That's a lot of references.
And my question to you is that, like, you did read or consider the documents provided to you by counsel?
I did.
That is why I'm putting to you that in the production of your work, you were required to work independent of a party to the proceedings, as your duty is not to the party to the proceedings, but to the arbitrator in this instance. Do you appreciate that?
I appreciate that, and I can assure you we worked absolutely independently. We have done all of this work pro bono, partly to ensure that we could maintain independence. In other words, the methodology was designed by me with the help of the team. If we'd arrived at a point where Section 27 was not happy with the report, that's what they would have had to accept, which is partly why we all worked pro bono, so that as mental health professionals we could be 100% independent.
Do you know when did you revise the report? Do you recall the date?
Which part of the Hillsborough, in terms of the Hillsborough report?
The affidavit which appears at LR 56.
The supplementary affidavit, because of the errors, was already in my mailbox. It was before the, where are we? Saturday was the 4th, so it was round about the 3rd or 4th of November.
In your testimony, you stated that it was on the 3rd of November. Will that be correct?
No, it was probably the 4th or the beginning of that week. So I had a supplementary affidavit to correct all the errors already. Then the request came in terms of the Hillsborough report. I think that was on the 3rd. And on the Sunday morning, which would have been the 5th, I read the document. As I say, I included 3 things, and then the document was submitted again.
Maybe let me assist you. Go to page 2 of that document, LR 56. Is that your signature? Like just above the name Coralie Trotter?
That's my signature.
You signed the document?
I signed the document.
Do you recall where was this affidavit deposed?
It was done at the Santon Police Station in Summit Road.
Do you remember the date on which it was deposed?
It was on the Monday, so that would have made it the 6th.
The 6th. Okay. Is there any explanation to reference of the date of October on the on the document?
I'm sorry, I can't see a reference to October.
Like just below sentence subs, like you see, it says like it was signed.
Oh, no, I mean, that should be November.
It should be November.
Should be November.
So it was not done on the 6th of October.
No, it was not done on the 6th of October. No, it was done on Monday.
So like at the time of signing this document, like you were not aware of this date.
No,
So like it was not signed in October.
it was signed in November.
Okay. Advocate for the Legal Aid Board, acting on behalf of those who have survived. You will recall that your testimony was that the report of your team was of equal application to those who have survived. Do you recall that?
It would apply, and then there would be some different things than that one would need to make sense of the survivors.
Were you giving an opinion when you mentioned that?
That's definitely my opinion, and that the impact will have been very similar in terms of what this report describes on the survivors, and then there would be additional dynamics.
Let's go to the report itself, starting from page 3, and help us and see if you can direct us to those aspects which relate to the survivors.
So the aspects that relate to the survivors would firstly be my whole introductory point, and then what leads into my first factor, and that is the whole concept of home. That to lose a home, to have a home, is a profoundly important thing in terms of one's sense of security. To lose a home is hard for anyone under any circumstances. When you apply that to psychiatric patients, it becomes absolutely critical. So in terms of the survivors, I haven't read their affidavits, but firstly, they were moved, and they were also moved without preparation. Secondly, from what I can gather, they were moved many times. And so for those survivors to now trust that the place they're in will remain a brick mother and a stable place is an extremely, extremely hard thing for them. I would anticipate, in my opinion, that the survivors now live with heightened anxiety about when they'll be moved again. That's the first thing in my report. Second thing in my report is they were also moved without consent, without their family members involved, and without any form of preparation. And I think I've made it clear how important preparation is. The third thing is that they were exposed to exactly the same dehumanization as the people who died were exposed. They were also exposed to an event that they were not ready for, which means that experience slipped in, and there's now a disjunct psychologically between the experience and owning it. So they are also traumatized. And then what will apply to them, which is in the report in terms of the families, but will also be true for the patients, is survivor guilt. It's wonderful to live, but it's a very, very hard thing to make sense of. Why me? How come I lived? So they've got that added dynamic. That's how my report applies to the survivors.
Let's look at page 3, like where it is recorded that this report is written in the memory and honor of those who died silently and the families who love them.
That's correct.
Do you see that?
Yes.
What I was asking you is, as I understand, your testimony is based on the report that you have prepared and which is before these proceedings,
Correct.
which has been made available to us
Correct.
in respect of what you will be testifying on.
Correct.
Where in your report do you deal with issues relating to survivors?
Justice Moseneke, that's a very confusing question for me because what was I meant to do with a cross-examination? Say to everyone, I'm sorry, but that's not in my report and I'm not prepared to answer that.
I asked your opinion. I sought to know which parts of your findings would extend to the experience of survivors. And you were obliged to give that answer because I put it to you.
But this question is now confusing for me because obviously my report doesn't include the survivors.
No, you're invited to give an opinion, but your report is your report.
So my report doesn't include reference to the survivors.
So without having assessed the circumstances relating to the survivors, you cannot be in a position to formulate an opinion.
I think we've arrived back at the dilemma we were dealing with on Friday, and perhaps because these things are so obvious to me, I didn't make it clear that although we all have individual variation, the bottom line is that we're part of a species. It's a human species. And therefore, we all have a body that's going to react in a similar way and a mind. So if I were a cardiologist, I would be able to predict what will happen to the heart. The mind is an organism, and whatever differences there are, because that's my area of expertise, if a certain stimulus is imposed on the human mind, I am able, like anyone else who's qualified and trained, to predict the outcome, A. B, if I leave here today and someone rushes in here with a gun and grabs Justice Moseneke and rushes out, I know that everybody in this room would be able to predict that not only is Justice Moseneke traumatized, but that everyone watching was also traumatized.
I better stay not traumatized if I'm to make the decision in the end, but let counsel continue with these questions. If we get back to that same legal point, we'll have to pause there and talk about it. Experts are different from ordinary witnesses because ordinary witnesses have to testify about their own experiences. Experts are called precisely for the reason that they ought to give opinions.
I'm learning that.
They are not required to give non-hearsay evidence or direct evidence. And that's why you can be asked to give an opinion on, provided that they are properly premised on a set of facts that are already before the courts, or facts that can properly be deduced. So experts are a particular class and category of witnesses for the knowledge they have, their experience, and the technical ability that they've built over many, many years. That's why before you gave your evidence, you had to tell us what your qualifications are, what you've worked with. That entitles you to express an opinion, as distinct from only relaying what you saw or felt or thought. Very well, but let counsel go on. I've checked the law again over the weekend, and that is the law. But let's hear questions that you might have and continue, counsel.
Justice, I submit that, like, in fact, it might be an opportunity that we request that justice should make a ruling on the difficulties that we have had with this witness. Since Friday, it has been our position, and it is still our position today, that the witness is entirely relying on hearsay evidence. And what we submit is that the rule of hearsay evidence is applicable to experts as well. And from what the courts have decided is that when such a situation arises, is for the presiding judge or the arbitrator in this instance to make a determination of the admissibility or otherwise of that evidence in order to avoid a situation where a lot of time is spent on information which is purely hearsay. And if
What you say is hearsay here, that the witness has said up to now.
Justice will recall that the witness testimony is entirely based on a report, on information which she was not privy to. There are people who were privy to the findings of fact. It is on record that she had clearly indicated that she did not interview any single family member. All that she relies on is on her colleagues. And those are the people who has the better position to express themselves. And as I've indicated, an opinion should be based on facts which are known to that expert. And in this instance, we submit...
Which, in your argument, are collected only by that expert?
Indeed.
Do you have authority for that proposition?
Yes.
That an expert may express an opinion only on facts collected first-hand by the expert? Do you have authority like that?
Indeed, Justice. If I can refer Justice to, there are two judgments. One is the judgment of the Supreme Court of Appeal in the matter of PricewaterhouseCoopers, Inc. and others versus the National Potato Cooperative Limited, IMF Australia Ltd, as the second respondent. It's case number 451 of 2012.
I'm sorry, the citation I'm not familiar with. Is that an SCA citation?
Yes.
Unreported?
It's unreported.
Just give us a proper citation, please, so that we can find it.
Okay. I have a copy, if I can just hand up a copy of the...
Yes, certainly.
Justice, I can refer you to all South Africa reports for that judgment if it exists.
Oh, yes. Do you have the proper citation? All South Africa, yes. What is it?
It's number 2, all South Africa, 403,
Yes.
Supreme Court of Appeal.
Thank you. Yes, counsel. Let's proceed.
And
You're going to refer me to the dicta which supports your proposition.
paragraph 80 of the judgment. Yeah. And which is that, in my view, notwithstanding the stance of PwC's counsel, the trial court should have intervened once it became apparent, as it must have done within a couple of days of Mr. Collett commencing giving evidence, that it was overwhelmingly based on hearsay. The basic principle is that while a party may in general call its witnesses in any order it likes, it is the usual practice for expert witnesses to be called after witnesses of fact, where they are to be called upon to express opinions on the facts dealt with. Dealt with by such witnesses. While the conduct of the trial is usually a matter for the parties to determine as they present their cases, I have no doubt that in the exercise of a judge's power to control trial proceedings,
Trying to follow where paragraph 80 takes us to. I suppose is the way it has just been.
I apologize for the manner of copying.
Yes. While the conduct, okay, I've come to it. I think it's more the collation of the document is insequential. Very well, I've got it, thank you.
Yes, like if I can just repeat the last sentence. While the conduct of the trial is usually a matter for the parties to determine as they present their cases, I have no doubt that in the exercise of a judge's power to control trial proceedings, the judge may intervene to ensure that they are conducted in a manner that avoids delay and the unwarranted escalation of costs. Two courses of action are open to the judge. The first would have been to require NPC to identify the hearsay evidence that it wished to have admitted and make application for its admission on any available ground, and then make a ruling on its admissibility. Such a ruling could always have been revisited at a later stage of the trial if necessary. The second, insofar as it was indicated that witnesses will be called to substantiate the hearsay evidence, was to require Mr. Coller's evidence stand down until such evidence had been led and was properly before the court. That would have been an appropriate and permissible course for the judge to adopt. Instead, Mr. Collett was allowed to continue unchecked. And clearly, Judge, our concern is that we have raised our concerns regarding Mr.
Well, let's read 81 also. Would you just read 81 also? Because it is relevant.
Yes. Paragraph 81 reads that the next stage at which this issue could have been addressed was when Mr. Collett finished giving evidence and before he was cross-examined. Instead, he was cross-examined on the very evidence that was said to be inadmissible. The second time it should have been dealt with was at the close of NPC's case, but the court was not asked to make a ruling. Then at the end of the trial, after some 160 days had been spent on this evidence, it was submitted that it was all inadmissible hearsay. By then, of course, it was impossible to sort the wheat of admissible evidence from the chaff of inadmissible hearsay. And if I can also be permitted to refer to another judgment of the South Gauteng High Court.
Well, you got to show me authority that says that an expert witness may not express an opinion on a set of facts put before it. Where do we find that in the passages you have just read to me?
In addition to that,
This was a case where an expert sought to, where they spent 160 days cross-examining somebody without deciding on whether the underlying evidence is hearsay or not, isn't it? I haven't read the whole case, but the passages you read to me seems to sound so. Are we in the same terrain here?
In addition to that, I would like to refer to another
Further
judgment.
authority, yes, very
Yes.
well.
Yes.
Thank you.
Justice, this is an unreported case of the South Gauteng High Court, Johannesburg,
Yes.
under case number 11453 of 2007 in the matter between Nicholson, Charlene as the plaintiff, and the Road Accident Fund as the defendant. The judgment was written by Judge Wepener. And in relation to this judgment, I particularly want to refer to page 3, from page 2 of the judgment,
Yes.
paragraph 3. Where it records that a number of expert witnesses called on behalf of the plaintiff overstepped the mark by attempting to usurp the function of the court and to express opinion based on certain facts as to the future employability of the plaintiff and to express views on probabilities. It is the function of the court to base its inferences and conclusions on all facts placed before it. And then the court then referred to the judgment of State versus Harris and quoted the following passage. In the ultimate analysis, the crucial issue of the appellant's criminal responsibility for his action at the relevant time is a matter to be determined not by the psychiatrists, but by the court itself. In the appeal, this court must of necessity have regard not only to the expert medical evidence, but also to all the other facts of the case, including the reliability of the applicant as a witness and the nature of his proved actions throughout the relevant period. And if I can proceed to paragraph 4 of the judgment, which records that the further difficulty which I have to struggle with is the absence of the factual basis on which some of the experts based their opinions. In this regard, I agree with Mayor AJ, as he then was, in the matter of Matebula versus RAF, and where a passage was also quoted, which reads as follows. An expert is not entitled on any more than any other witness to give hearsay evidence as to any fact, and all facts on which the expert witness relies must ordinarily be established during the trial, except those facts which the expert draws as a conclusion by reason of his or her expertise from other facts which have been admitted by the other party or established by admissible evidence. So it is on this basis that the justice is called upon to determine one of the causes which have been set out in the PwC case, the PricewaterhouseCoopers, when this issue of hearsay evidence is raised. It will be a travesty for this process that a witness should go on and on and on and make statements which do not qualify as opinions because they are not based on facts. So it becomes quite critical that a ruling should be made on the admissibility of what Ms. Trotter is placing before these proceedings. Otherwise, it will then become very difficult at the end of these proceedings, where a witness even ventures to testify on behalf of other parties that of the other party that has not requested her to opine on the experiences of their own client. And like as I have indicated, the first issue is in relation to the 11 families which were interviewed by other team members. And the clear admission...
How do you say those facts must be placed before this hearing? Do you want every one of the team members to testify?
Justice, it is entirely upon the legal representatives of Section 27 to make that call, whether like they call one of them or all of them.
No. You saying the report is based on hearsay evidence. So I'm trying to understand. What do you say would be good evidence that would entitle the witness, expert witness, to make tender opinion evidence?
It is my submission, Justice, that like those experts will be better placed to come before these proceedings and express their opinions because they've undertaken the type of therapy that this witness has made reference to. So it is those witnesses.
Let's go through it carefully. Let's just calm it down and go through it carefully. We know the rule. You've just referred us to it on page 4 of the judgment. Okay. We know that an expert is allowed to use facts and from which to draw a conclusion by reason of his or her expertise from the facts which have been admitted by other parties or established by admissible evidence. So that has been the rule. There's always been the rule forever. The only witness that's entitled to express an opinion on facts established by others or facts that appear from the evidence, right? Now, you're saying there are no such facts. And I just want to understand your submission in relation to this case. Is the submission that those facts will be present only when those who compile the statements, only those psychoanalysts, experts in their own right, who compiled the statements, were actually called to say so? Is that what the submission is?
The submission is that like that should have been the proper course to have been taken, so that like those facts should be placed before the tribunal, before this process. Because as I've submitted, an opinion can only be based on facts.
May an expert draw inferences from a series of statements that purport to set out facts? If the statements are ultimately admitted into evidence?
Well, if I can answer that in relation to the PwC case, paragraph 80, like towards the end, where the court said that insofar as it was indicated that witnesses would be called to substantiate the hearsay evidence, was to require that Mr. Collett's evidence stand down until such evidence has been led and was properly before court. That would have been an appropriate and permissible course for the judge to adopt. And that applies in this instance, which is what we submit, that Ms. Trotter is in no position to deal with those aspects until those facts are placed before these proceedings.
And by those facts, you mean the members of the team ought to be called to say, I have made the interviews and drew up this statement, which ended up with Ms. Trotter. Is that what you say?
Justice, what has been led is that the members of the teams, they are experts in their own rights. So this report was based on their own findings. They are better placed to speak to the report.
Yeah, they're based on the recordals of the interviews they had with family members. So they wrote out statements which were submitted to Ms. Trotter. From those statements, she tells us in her evidence, she made certain conclusions which led her to a particular disorder. Now you're saying, in effect, you're really saying all of those who took the statement should come and testify.
Indeed so.
Is that
if that's what Section 27 intends to do, but insofar as this witness is concerned, we object to her evidence as purely constituted by hearsay evidence. And as to whether they take that course
But
or not.
opinions can be hearsay evidence. You mean the underlying facts that she claims she collated from the other statements? You see, let's not collapse a few things. The law is quite clear, all the passages you have quoted. An expert witness may formulate an opinion and put on the basis of facts, right? She does not have to produce the facts. If the facts are placed before an expert, the expert will provide and is entitled to provide an opinion. So the debate, as I understand you are raising, is there are no underlying facts. Is that right?
That is correct. Hence, we say the opinion is based on hearsay evidence, and therefore...
And the law allows that those facts be adduced before or after the expert witness, isn't it?
I've just read the paragraph that what is the proper course in those circumstances. The fact must be before court.
Yeah.
It cannot work the other way around.
Let's understand the passage. I don't want us to debate on the... Let's understand the passage you referred me to the SCA. A judge has three options. Could rule up front, could hear the expert evidence, provided the facts based on it would come later, before the close of the case, isn't it? From the passages you read to me. So, nor would a court prescribe the order in which witnesses are called. So if she, we'll hear them now. If they think that your point is good, then we're going to sit here and listen to 8 psychoanalysts who took statements. That is fine. It's a decision that Section 27 has to make, provided they think your attack is good. And that they can do after this witness or before this witness, on the authority you just read to me, as long as it's before they close their case, isn't it?
Justice, it is quite clear that the witness has already testified, has given her testimony.
I'm not sure about it being clear, but I mean,
Oh, please.
okay.
Well, like the submission which I wish to make is that the witness has already been led in chief.
Yes.
And that being the case, we object to that testimony. So that is the reason why we request you, Justice, to make a ruling on the admissibility of her evidence. That's what, like...
On the authority you've put before me, I have the option to make that ruling right up to the end of the case of Section 27, isn't it? Because if there's a defect, they may remedy it. It's just that simple. Or if there is no defect, then they go ahead. Then the point is still there for you to argue and say, don't admit her evidence because it was based on hearsay. That is the real procedural options that a judge always has. Object, hearsay, the judge says, I've heard the objection, I'll admit the evidence provisionally, and I'll decide at the end of the hearing. And the hearsay may be remedied by other evidence, or may not be remedied, or may not be hearsay. So, but I heard your point. You require me to make a ruling on whether, on what? On whether or not this witness should proceed? What should the ruling be?
To consider her evidence as being inadmissible on the basis of such evidence being hearsay, and therefore not continue to testify on matters which she does not have knowledge.
Does a court ever be required to do that in media res, right in full flight of a hearing? The evidence, the witness finishes, you make your points, and you say it's hearsay, and the discretion sits with the presiding judge at the end of the hearing. Where have you ever had a witness be stopped midway and say stop?
Well,
you may criticize the evidence, but you can't stop the witness.
what we submit, Justice, is that for the sake of these proceedings and not to be overburdened with information which will ultimately be of no use to the proceedings, it should be an appropriate moment for the justice to make a determination. Either way, whether the justice overrules on this aspect or not, it's a totally different matter. But in the interest of the proceedings, that determination has to be made.
So you invite me to make what determination? That those witnesses must stop testifying?
That the evidence given on is inadmissible.
And what is the authority for that proposition? Let's go back to the PricewaterhouseCoopers case. It sets out the options that a judge has. And those options extend right up to the end of the case. And very logically so, isn't it? Let's go to paragraph 81 again and show me where a judge could throw a witness out on the grounds of hearsay. Let's look at the middle of 80, starting with 80, for instance. The basic principle is that while a party may in general call its witnesses in any order it likes, it is the usual practice that the expert witness to be called after witnesses of fact, where they are to be called upon to express opinions on the facts dealt with by each witness. While the conduct of the trial is usually a matter for the parties to determine as they present their cases, I have no doubt that in the exercise of a judge's power to control trial proceedings, the judge may intervene to ensure that they are conducted in a manner that avoids delay and unwarranted escalation of costs. Two courses of action were open to the judge. First, it would have been required to require NPC to identify the hearsay evidence that it wished to have admitted and make application for its admission on any available grounds, and then to make a ruling on its admissibility. Such a ruling would always be revisited at a later stage of the trial if necessary. The second, insofar as it was indicated, the witness would be called to substantiate the hearsay evidence. was to require that Mr. Collett's evidence stand down until such evidence had been led and was properly before the court. That would have been an appropriate and permissible course for the judge to adopt. Instead, Mr. Collett was allowed to continue unchecked and here for 160 days. Those are the specific facts of that case. But those are options which a presiding judge would have. That's why it's may. In short, the judge must control the case in such a way that doesn't lead to wastage, to a lot of time, but the party, any party may anytime remedy any hearsay if there is any. But you've got to finally decide what you're calling me to do, upon me to do. I'll hear your other colleagues because this is an argument on admissibility. I think have you made all your points, and what order do you desire I make at this stage?
We seek an order that Ms. Trotter's testimony is considered to be inadmissible on the basis of it being hearsay.
You want an order for me to rule that the entire evidence is hearsay?
Indeed so.
Very well. I think that is clear what you're asking for. Thanks. Let me hear what your colleagues say. Let's start off with Section 27. You called the witness. What is your response to the legal arguments on admissibility that have been made?
Thank you, Justice. My colleague has referred us to two cases. The interpretation of these cases by my colleague is an astonishing misinterpretation of the nature of expert evidence. Expert witnesses are witnesses of a special character. They do not provide evidence to the tribunal as direct witnesses. They need not have had direct sensory impressions in order to provide an opinion, provided the opinion that the expert is expressing is based on facts that are before this tribunal and before the hearing. That expert may express an opinion. What facts is it that Ms. Trotter is placing her opinion on? She is placing her opinion, basing her opinion, first of all, on the Ombuds's report, a lengthy report, all the facts of which have been conceded by the state. Those are common cause facts, let alone simply evidence that's been led in this tribunal. Those are common cause facts. My colleague speaks about the interests of these proceedings. I'm afraid that he's showing the hand of the government by trying to dislodge this witness, by saying it's not in the interest of the proceedings to have an expert provide an opinion to you, Justice Moseneke, not to us, to you, on what the trauma is, whether there is trauma that would result from those facts, and what type of trauma would ordinarily result from those facts based on her expertise. That is what she seeks to do. She seeks to assist the tribunal. She seeks to assist the arbitrator. In fact, if you have a regard to the first page, the covering page of the report clearly says arbitration by Justice Moseneke is provided for the purposes of the arbitration. It is not provided, as my colleague seems to suggest, for the purposes of Section 27 and some nefarious motive by Section 27 to pull the wool over the eyes of the arbitrator in this hearing. It's provided directly to you, Justice Moseneke. I said it's based on the facts of the Ombuds's report, but that's only the beginning of it. It's also based on testimony and evidence that has been led in this hearing thus far. There's a reason why this expert is providing evidence after the testimony of the families. The witness has already told us that she has heard and listened to all of that evidence that's been led before this hearing. The witness also bases her opinion on the work of a team, on a team of 19 professionals, experts in their own right. She says she does so based on a particular methodology. She sets out the methodology in her report. The methodology was to work together with the team in order to gather the facts and to gather the reports of experts, not just any ordinary person. And through that research, prepare a report that might be of assistance to this tribunal. Not only that, Ms. Trotter also tells us that so concerned was she about the integrity of the process that she ensured that, the process was independently peer-reviewed. The process was peer-reviewed by an attorney and a professor, an expert in psychoanalysis, to provide oversight to Ms. Trotter and her team. On the basis of those facts, Ms. Trotter is offering an opinion in order to assist this process. The PricewaterhouseCoopers case, as well as the case that we've just been referred to, Nicholson versus the RAF, and especially the paragraph read out by my colleague, is of no assistance to him. The paragraph that he has quoted, and I'll repeat it. It says, an expert is not entitled, any more than any other witness, to give hearsay evidence as to any fact. And all facts on which the expert witness relies must ordinarily be established during the trial, except those facts which the expert draws as a conclusion by reason of his or her expertise from other facts which have been admitted by the other party or established by admissible evidence. That is exactly what I've set out, the 4 or 5 different categories of facts upon which Ms. Trotter is basing her evidence. I would take this opportunity also to say that my colleague seems to insinuate there was an improper influence by myself. He specifically referred to counsel for Section 27. He insinuates that there was improper conduct by me, and I take objection to that, and I deny that there was any improper conduct. The team, the legal representatives for the families, did indeed retain the services of Ms. Trotter, pro bono, and her entire team, pro bono. Not for payment, not for reward. There's no reward that these experts will gain from the participation in these proceedings. In the course of retaining her services, documents were provided to her in order to assist her to undertake her task. All of those documents are in evidence before the court. The affidavits are all in the bundles that are before this tribunal. The testimony that's been led is the testimony that's before this tribunal, upon which Ms. Trotter based her facts, and so on. Ombuds report, common cause facts. So this, I'm afraid to say, is a gross misinterpretation by my colleague of the state of law of expert evidence, and were this tribunal to uphold the argument of my colleague, it would make a nonsense of the need for expert opinion in matters. The reason we need expert opinion is because none of us, and particularly you with respect, Justice Moseneke, don't have the expertise to draw inferences and deductions and conclusions regarding the psychological impact of the facts that are at play in this hearing. Ms. Trotter, however, is an expert who can advise us as to the trauma that is likely to result. What can be predicted from the facts that are at play in this hearing? I would like to refer Justice to another judgment, which I believe is unreported, and I can provide Justice with the Safley citation. Justice, if I may do so, perhaps a little bit after the recess, because I thought I had the citation with me, but I don't. But the case name is AD, initials AD, versus the MEC for Health and Social Development, Western Cape Provincial Government. It is a judgment by His Lordship, Mr. Justice Rogers, in the High Court of South Africa, the Western Cape Division. I'm just going to the relevant paragraph. It's a matter in which the Justice had to consider the value of expert opinion and the basis upon which experts may draw opinions and provide opinion evidence. And he begins his assessment of what he calls a heading, assessment of expert evidence, at paragraph 39 of the judgment. Justice, my colleague has very helpfully provided me with the Safley reference, so I can provide it to you right away. It's 2016, ZAWCHC 116. And the judgment was delivered on 7 September 2016, and it makes reference to PricewaterhouseCoopers and applies PricewaterhouseCoopers, the judgment of 2 years before this particular judgment. And at paragraph 40 of this judgment, His Lordship refers to the very same extract that both my colleague and I have read out to you in relation to what an expert is entitled to do and not do. He then, in paragraph 41, refers to United Kingdom Supreme Court judgment, which reviews the principles relating to expert evidence and why they are relevant to our law. And then in paragraph 42, referring to the UK Supreme Court judgment, and now I quote, he says, "An expert may draw on the works of others, such as the findings of published research or the pooled knowledge of a team with whom the expert works." The expert, it goes on to say, must demonstrate to the court that he or she has relevant knowledge and experience to offer opinion evidence. My submission is that this expert has done so. It was put to counsel at the start of Ms. Trotter's testimony whether they object to her expertise. They did not object to her expertise. On the basis of the law as it stands and the references to the judgments put to yourself, Justice, by my colleague and by myself, and from the overwhelming evidence that's already before this tribunal, I ask you to not grant the relief that my colleague seeks to dismiss the evidence of Ms. Trotter. The point is wholly unfounded on hearsay evidence. It's a misinterpretation of the hearsay rule. And so we, on that basis, say that it has no application. There should be no further truck with this line of argument. and that ruling should not be granted. But I'd like to add one further thing for the record, that to the extent that we were, and in the interests of these proceedings, which are of a special nature itself, and we are all here to get to the truth. And in the pursuit of that truth, we tended to provide confirmatory affidavits by the other psychologists who were part of the team to confirm that the references to them in the report are true and correct. We tended to do so over the weekend. The States Council objected and refused to accept that evidence. I don't understand the motive of the States Council for taking the points that they are now taking in relation to a witness whose task is to assist you. And those are my submissions on the matter.
Thank you. Advocate Harson. Advocate Krauss.
Thank you, Justice Moseneke. I'm going to endeavour not to repeat what was already said by my learned friend, Ms. Hassan. I would urge this court to dismiss the application by the state. And this court knows very well, with respect, the principles on which expert evidence rests. You need the expertise of the person, that's already before court. You need the independence of the person, but that will be determined by this court at the end. The court will then look on the facts on which the opinion is based. And the court will determine whether the facts on which the witness based her opinion was the proper facts. But that's not for this court to decide that now. The court will also look at the process, whether it's a scientific process that can be repeated, and that's the Dilbert principle, of course. So our submission is simply the elements of expert evidence is before this court. This court cannot rule this evidence inadmissible at this stage. The court will, of course, evaluate whether the court trusts this witness, but this is an evaluation that the court will do at the end of the hearing. Those are our submissions.
Thank you. Advocate Quillevard.
Thank you, Justice. Justice, say for submitting that we fully support the arguments presented by both Section 27 and Legal Aid SA, and that we are in support of the contention that the application of the state be dismissed. We can only add to the fact that, as Justice has pointed out, this is a process sui generis, and to now apply legal principles that is attempting to prohibit this arbitration from hearing facts and evidence which will support and assist the justice in making a ruling is not to the benefit of these proceedings, and therefore we submit that this application should be dismissed.
Of course, arbitration must be in accordance with the law.
Indeed so, Justice. Indeed so. But as indicated, we submit that the legal arguments presented by Section 27 and Legal Aid SA is sound, and there is no reason to doubt same, and there is no reason to uphold the argument presented by the state. There is one other issue, and that is the issue of the admissibility of hearsay evidence in any event. And Section 3 of the Law of Evidence Amendment Act clearly state that one of the factors, should the justice find that it is hearsay evidence, is that it can be admitted in the interest of justice, and having regard to the proceedings, and having regard to the probative value of the evidence, and so on. So, irrespective of the fact that counsel is arguing that it's hearsay evidence, to the extent that justice might want to consider that it's hearsay evidence, it can still be admitted. But we stand with the argument in support of Section 27 and Legal Aid SA.
Very well. Counsel. Do you want to make any submissions?
Thank you, Justice Msanek. I think the issue has been properly traversed. The only thing that I will add on is that my understanding of the issue is that that is the expert opinion moves from a premise that there is a home, there's a brick mother, and so on, and that is established by the fact that we're dealing with mental patients who were moved from life as Esidimeni. That is the home which was disrupted. Then from there, those are established facts, and they appear from the Ombuds report. And from there, they were moved to different entities or different homes, which, as I understand, the concept of home, as has been testified to by the expert, was disrupted. That is one. Then the question is, have we established as a fact that these patients were moved from one home to another? That is the answer to the rest of the question is that yes, they have been moved. And the objection to the witness, that is to the witness evidence, is that the evidence that has been led is based on hearsay, or it is hearsay. Whether the fact that patients were moved from one place to the other is hearsay or is a fact, I don't believe that that can be hearsay. And what follows thereafter is that whether is an expert entitled to base his or her opinion on that fact to make that is an expert opinion, whether the fact of the move of these patients had an impact on them or did not have an impact on them. Those are my opinion. Those are my opinions on that.
Should I grant the application?
In my view, the
application to declare that the evidence of this witness is hearsay, and she's not permitted to proceed therewith for that reason. Now in race media.
No, on the basis that the facts are established on the basis of which the opinion is based or is made, the opinion is not based on hearsay evidence.
Should I uphold the application by the state?
No.
Very well. We're back with you, counsel. Before I make a ruling, is there anything else you want to say? And I think possibly the most important thing you have to address on this hearsay argument is your platform not narrow? You're looking at 11 statements. But we have been here for 4 weeks, 5 weeks. By agreement, the Ombudsman's report was admitted by all the parties. We've had how many witnesses? Not even one of them was challenged on their evidence. That was accepted unchallenged, followed only by an apology. Totally startling, maybe. Your colleagues suggest that you should now say all these are hearsay facts. Even without the 17 other people, would we be in the terrain of hearsay, where all the facts have been admitted over a hearing of 4 or 5 weeks? So I think that's what your colleagues are saying. You ought to admit that. It goes way beyond the statements reduced to writing by the other experts. And they make the other point that whether you want all 17 of them to come and just say that, which was never disputed. Anyway, what's your response to your colleagues' arguments?
Justice, I think like what we have to take into account is that the witness testimony is in relation to her establishing the extent of the trauma suffered by the families. It is indeed correct that the Ombuds report has been admitted to the extent of the occurrence of the deaths But what we take issue is that this witness testifies about the issues relating to trauma. And we all know that the next aspect, which has to be decided by this, by this tribunal, is the aspect relating to compensation. And compensation has to be measured against the extent of trauma suffered by the family members. So it is on that basis that it becomes very critical that those facts should be placed before your justice.
No, but then
So
the
that
end-
when that moment comes
Yes.
for the determination of compensation, it should be known to what extent has there been suffering.
Can't you at the
And by
end of the
who?
hearing say, oh, there was expert witness exaggerated, or the expert witness not to be relied upon, the expert witness overstated the extent of the trauma? Quite different from saying evidence is inadmissible, isn't it?
Well, Justice, the challenge is purely that we are now being forced to cross-examine a witness when there is no factual basis laid. That's where the challenge is. So that is why we submit and persist that the proper course was to lay the ground where people with first-hand information will be able to give evidence.
What first-hand information? The one recorded by clinicians. We've had direct evidence. We've had people come here and cry and scream and tell us what they experienced. We've had evidence about the movement, about hurried, unprepared placement of patients. We've had evidence about their hunger, their death, their pain, their everything else. We've had it directly from them.
Well,
Clinicians are told what we have already been told in this hearing, okay? So they themselves are second-hand reporters of what they have been told. You understand that? So when you say there are no facts, it's something that you ought to really argue to persuade me that there are no facts before me about the movement from their homes, about the hurried movement, about inadequate medication, about no hospital records, because this is not contested, and about the Ombuds report, which is before us, uncontested, about deaths, which are 143, about, let's go on. Clinicians recorded in statements what we have already been told. So what facts do you say are not before us? Which a clinical expert, a clinical psychoanalyst can't make expert inferences from? I think that there is I haven't made a ruling. I'm just putting it to you to argue that point, because I'd like to hear you on it.
Justice, the role of an expert witness is different from the other witnesses who came before these proceedings. And that role is to assist you as the arbitrator to be able to understand the nature and the extent of the harm suffered by the families. So the expert's testimony cannot be compared to what other witnesses had already testified on about the events. So what we say is that we have already heard from Ms. Trotter herself that amongst other important considerations during the interviews is to consider the demeanor of those who are affected in order to be able to make an assessment.
she's told in statements about the demeanor, and she has had the evidence, open, viva voce evidence about how the people felt. What else should an expert go and look for?
Well,
Personal sensory experiences, is that what the argument is?
that is the method that Ms. Trotter has testified that that method was used. And
No, didn't she say they used a team? Didn't she describe the method and how do you distill the recordals of her colleagues and impressions, and they all get garnered into one place as a team, and then inferences are made? But be that as it may, I think you must finish your argument.
Yes.
I was giving you an opportunity to respond to the earlier responses of your colleagues to your argument. And there are three in main. One is the affects. She doesn't rely on hearsay evidence. Two, and admitted facts. Two, she's an expert and nobody suggests that she's not. Three, in any event, judges decide at the end of a hearing whether hearsay evidence ought to be given any weight or not. Isn't that our law now? No judges are called upon to make decisions on hearsay evidence in race media, in full flight of a hearing. It was a law many, many years ago. You hear out a witness, and in the end, you can argue that I should place no reliance on it, or little reliance on it, or throw it out as a bad expert, but you don't stop witnesses. But you require a ruling, make your submissions, and I will do so.
Justice, our responses are that firstly, on the aspect relating to facts, we stand by our submission that there are no facts placed before your justice, and the witness relied purely on the hearsay evidence by other experts. And secondly, on the issue relating to the nature of these proceedings, where it has been suggested that it is sui generis, therefore the evidence should be admitted. We submit that even if it is so, we still have to operate in terms of the established legal principles. There is no reason to deviate or to depart from what the law provides. And that will be able to assist us in dealing with this.
Yeah, about that you're right. The Arbitration Act is clear.
Yes.
We operate within the law. So there's no, there are bigger issues that you may want to respond to, but if you're done, I'll make a ruling and so we can proceed.
Then the other issue relates to whether, having admitted the content of the Ombudsman report, but does that translate to the admission of the extent of the harm suffered by the families? Because it's essentially what this witness is before this proceedings.
But this is startling, counsel. Isn't it the witness of the witness of the witness? You were talking about the severity of the experience and so on. You and I are not clinicians. We're not psychoanalysts. Somebody must tell us what all this is. What does it mean? What kind of trauma does it invoke in people who are exposed to this kind of situation? Isn't it so?
Well, Justice, our last submission is that.
Why would this witness incompetent to do that? Why?
Our last submission is that this witness is supposed to assist these proceedings by formulating an opinion. So what we say is that her opinion will be flawed if it's not based on established facts before this tribunal. Those are our submissions. And we request your justice to make a ruling on that matter.
Your application is dismissed, and we will now proceed, and the reasons for the decision will be set out in my award. And no further line of cross-examination that seeks to impugn this evidence only on the grounds that is hearsay will be permitted. May you proceed with that cross-examination, please.
Thank you, Justice.
Thank you, Justice.
Ms. Trotter, you will recall that yesterday during your testimony, you indicated that there was a person who was interviewed, and it was established that that person did not suffer trauma. Do you recall that?
Correct. Correct.
So, if, according to your assessment, that amongst other people who were interviewed did not suffer trauma, then on what basis will you then seek this tribunal to extend the findings of your report in respect of 11 families to all the other families?
On the basis that we all have a human mind, and so although there will be differences in terms of how we respond, if someone's had a lot of loss in their lives, that might affect how they respond to trauma. In this particular case, the person relies hugely on faith, and that mitigates against it. What I'm absolutely clear about is that everyone who has been through this experience is traumatized, and hugely traumatized. Then it may be that there are some variations. The human mind, if exposed to a particular stimulus, neurologically, biologically, responds in the same way.
And then how did you come to the finding that the person interviewed did not suffer trauma?
So the interviews were conducted, and then the pair that conducted the interviews wrote up reports, which they gave to me. There were times when I asked for additional information. I know that your argument is that I should have been there, but in fact this method relies entirely on my not having been there, because I have a totally objective view once I sit with all of these reports in terms of finding ongoing themes. And those themes eventually reached a saturation point. So I read every single report, and then, because I know what the signs of trauma are, I could see this person is traumatized, this person is traumatized. In the one report, there was no sign of trauma. And then I checked with the two people who had done the interview and said, is it correct that this person is not traumatized? And they said yes. Then when we all met, finally, after I'd written my report, what I said to everyone is, listen very carefully, because I want you to be sure that everything I've said in this report is an accurate reflection of your clinical judgment and all the information derived from the interviews. So I'm looking for themes in the reports objectively, and I know what trauma looks like.
Well, the question was, how was the determination made in relation to the person who did not suffer trauma?
There were no signs and symptoms of trauma reported in the report.
In relation to those other family members that your team did not interview, is it unlikely that there may be others who are in the same position with the person that you said you could not find signs of trauma?
There may be other people who also were not traumatized. That will be very low, that number.
There may be other people
There may be other people
who did not suffer trauma.
who did not suffer trauma, but it will be a really low number.
Thank you. I therefore put it to you that your methodology cannot be relied on by these proceedings by virtue of your evidence that you have already established that there was someone who was interviewed who did not suffer trauma. And you have already testified that there may be other people who did not.
Well, let counsel finish the proposition, and then you raise your objection. Yes, would you complete your proposition?
Thank you.
There's a pending objection, but I think you should finish the point so that we can hear what the objection is. Please proceed.
Thank you, Justice. What I was saying to you is that, like, I'm putting to you that your methodology cannot be relied on. Firstly, because you have said that your team has found that there was someone who did not suffer trauma. And in your expert testimony now, you also confirm that there are other people who may not, I mean, of those who have not been interviewed, there may be those who have not suffered trauma. So what I'm saying to you is that your testimony in terms of the method that has been applied in order to assess the extent of the trauma cannot be relied on because of your failure to have interviewed all affected families. What's your response?
Before you respond, there is an objection.
Justice,
Advocate.
what my objection is, and why this question should be disallowed, is because my learned friend is not an expert. It's not competent. It doesn't lie in his mouth to say that the methodology is incorrect because he is not an expert. The expert report has been before this hearing and before the State's Council from the very beginning. Had they wished to call an expert to make this proposition, then they should have done so. But I request that that question be disallowed.
No, I think the objection is not granted. Counsel need not be an expert to be able to question an expert opinion. And the witness is here, can defend the methodology. She is here. But we don't have to be experts to listen to experts and to test whether the conclusions they make are reasonably supportable. So the witness must reply to the question and say why the methodology is defensible.
The methodology used is essentially how all epidemiological research is undertaken, where you might see that there's a particular kind of problem, for example, that we have a major problem in South Africa with tuberculosis, and you might then be wanting to look for something in terms of the impact of having tuberculosis, which would be like the trauma.
Well, let's. I think I invite you to confront the criticism. The criticism is that the methodology you have used is not supportable, or is not to be supported, because you have not interviewed everybody or you have not made everybody who has been a victim part of the cohort. That is the essence of the criticism. So if I invite you to meet that criticism.
So in terms of this type of research, you would always choose a sample out of the big pool, whatever it is that you were looking for, and then you would look for saturation themes. You'd look for the same thing coming up over and over again. If you're trying to find out something about HIV, you don't go interview everyone in the country who's got HIV or who's got TB. Nevertheless, it's well established that the conclusions experts in that particular field arrive at, based on a small sample, are absolutely accurate and founded. That is the methodology. I haven't used a methodology that isn't well accepted epidemiologically. And I put in very, very specifically, because the nature of this situation, 100 checks and balances, as I explained last time, because of my distress that a ball could be dropped.
The peer review,
Exactly.
safety.
Yeah.
Very well, that's the answer.
Thank you, Justice. May I request that I proceed after the tea adjournment?
Yes, are we there already? Yes, very well. Yes, you may. Indeed, you may. We're going to require you after tea. We're going to resume at 12 midday. It's 11:30 now. Shall we adjourn now till 12 midday?
We have a new TV.